Hey, good morning, everyone. In History of the U.S. Constitution, I'm going to put up a quick video concerning the Fifth Amendment, and I might tie not the video, but the homework assignment to Amendment 6 as well, because they overlap significantly in the sense that they're almost all related to criminal procedural rights. The first part of the Fifth Amendment basically says no person shall be held to answer for a capital, which means basically you're subject to the capital punishment, death, and or otherwise infamous crimes. That's been interpreted to mean a felony. So in the state of Massachusetts, in order for the government to go forward with a felony prosecution against you, they have to go through an indictment process through the grand jury, and that's what it basically says. It says unless a presentment or an indictment of the grand jury. And that's what the difference between a trial jury is, those things you watch on TV where there's jurors determining whether you're guilty or not guilty. That's a petite jury. And I love that term. One time a judge says, "Are you seeking a petite jury?" I don't care what. I didn't know what he meant. And I said, I see the clerk sitting in front of him kind of nodding at me, say yes. I'm like, yes. I just never heard it called that before as an attorney. But now understanding what that judge said makes it kind of interesting, because a grand jury, meaning a large jury, Massachusetts, 23 people usually sit, 12 of which have to determine whether or not there's probable cause. Not whether you're guilty or not guilty, just whether there's probable cause to determine whether you should be held for trial. There's just a probability that a crime has been committed. A lot of people think it's unfair because they're secretive. The public doesn't usually know about it. The defendant rarely gets to participate in it unless the government wants them to. And you can't present evidence on your behalf, and the evidence is completely one-sided. It's almost all pro-prosecution. So there's an old saying by a famous attorney here in Massachusetts named Max Stern that said you can indict a ham sandwich for a crime in the state of Massachusetts. But it's true of every state that has a grand jury system, and most states do, and the federal government does. This is the amendment for the federal government, but most states have a very similar governmental system in their judicial structure. We do in Massachusetts. We do have the grand jury system. We also have a second system in Massachusetts that in order to be bound over for a felony, you can have what's called a probable cause hearing. I'm not going to test you on it, but there's just two paths. Thought you might be curious. Again, a grand jury is secretive. They get information presented, and they don't determine whether someone's guilty or not guilty. The grand jury determines whether or not there's probable cause. It's a safety valve, trying to weed out very weak cases that the government's trying to go after something. Because what don't we want? We don't want a government of tyranny. And so if the government's going to charge somebody, you've got to present it basically to this neutral group, the grand jury, citizens between the ages of 18 and 70 from the community. They have to determine there's just enough evidence to go forward. And I got to admit, because there's a one-sided presentment of facts, most people that go through that process do get indicted. Which is the charge. Most people don't care that much about that part of the Fifth Amendment. It's an important part. What's controversial about it, though, is the secretiveness to it, because sometimes a grand jury returns it's called a no bill, meaning they didn't indict, and people are shocked by it, especially when a cop shoots somebody, an unarmed suspect, and then they say, well, the cop's going to be charged with manslaughter or murder because it doesn't look like the police officer was justified in shooting that person. Therefore, it's a type of homicide. And a lot of times the grand jury doesn't come back with an indictment. They find a no bill, and the public gets outraged, and there's protests. Sometimes there's riots and looting and all this other stuff because they can't believe the grand jury did it. And there's a lot of criticism because the grand jury is secretive. But you have to remember the other side of the coin. Why are grand juries secretive and we don't get to participate and watch what's happening? Although everything's recorded in a transcript, so you can read it after the fact. Is because if we know the grand jury is happening, what could a defendant do with potential witnesses? Kill them, bribe them, hide them. And the same thing is true about evidence. Maybe evidence is out there in terms of documentation. What could the defendant know if they were being subject to an indictments process? They could destroy documentation and other evidence that could be inculpatory, prove their potential guilt of a crime. So I think the secretiveness of the grand jury is probably here to stay, because it does serve a bit of a valid public purpose, because otherwise people would be threatened if you knew they were going to testify and things like that. I think they still can figure it out, but it's supposed to be secretive. The next one, which is more important that most people are interested in, nor shall a subject be tried for the same offense put in jeopardy of life or limb. What does that mean? Double jeopardy. Well, it's only after a verdict. So say I get charged with a crime today, and for whatever reason, the government can't go forward, so they dismiss the charge. Could they bring up that charge later? Yes, they could, because they might not be able to for other reasons, but not for double jeopardy. Double jeopardy is only after a petite jury, a jury of my peers. Superior Court's 12, District Court's 6 if you're curious. Federal Court is always 12. They come back and return a verdict of guilty for me. I do a 1-year sentence, I get punished, I do my time, I'm out. What if the government doesn't like me? Can they say, let's try him again for that offense? No, it's over. I've already had a verdict. I have a guilty verdict. I've already been punished. Well, that's the most obvious one. But the one that troubles people is, okay, I have a jury trial. I'm charged with bank robbery. I'm found not guilty. And then the government later on says, geez, he got away with one here. And they find other evidence, other witnesses. Maybe there's video that they didn't have before. Now my car's on the video driving away from the scene. And maybe right after that, I pull off a ski mask or something that's clearly identifying me as the perpetrator. Can they now retry me? No. Double jeopardy says no. So that's outrageous. But think about why it's actually a pretty darn good rule. Because in our framing of our Constitution, that's what the British government was doing to some of the early civically minded citizens of New England, especially Massachusetts. They would try him for a crime. The jury would find the defendant not guilty, and then the British government come right back at you for the same exact crime, for the same exact date and time. When does justice close? We have to have closure on cases. So once a verdict's done, they can't retry you for it. So a lot of people like to bring up the O.J. Simpson case. He was tried. He was found not guilty. Then people thought he might write a book, something about if I did it, or maybe he'd admit to enough facts in the case to prove, could they retry him? No, they couldn't. However, very few people who are found not guilty of a case are willing to come forward and say, yeah, I did it, but double jeopardy protects me. Why? Because you could still be sued civilly, just like O.J. Simpson was, and I could lose millions of dollars because maybe the wrong I did is not only a criminal offense, but maybe I harmed somebody economically or physically, and they could sue me for personal injury or personal damage to their property. So why would I admit it? Because I'm still at risk. It doesn't apply to civil cases. Double jeopardy only applies to criminal cases. That's one issue. And the other is maybe I testified in my trial that I didn't do some act. I'm found not guilty. Then I get out on the front step and goes, yeah, I did it, but I smooth talked the jury. They didn't think I did it. Ah, ha, 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 ha. Could I be charged now with perjury? Yeah, because now they're charging me with a different offense. They're not charging me with the same offense. So it's rare, although the movies are made about it, books are written about it. I think TV shows often portray this issue of double jeopardy where someone's found not guilty of a criminal offense. Then they tell their attorney or they reveal to some other people later on that, yeah, they did it, but double jeopardy protects me. Let's face it, that's a very narrow negativity to the Fifth Amendment aspect of double jeopardy. It's rare that comes up. We need to have closure of cases, whether it's a conviction or an acquittal. The next one a lot of people like to talk about and be informed of I'm going to the Sixth Amendment. Nor shall they be compelled in any criminal case to be a witness against himself. That's the so-called Miranda Warnings. I'll get to that in 1 second. So basically, you can't be forced to testify against yourself. And this used to come up in trials a lot where my client would not want to testify to get up on the stand and say they're not guilty. I'm a little different than most defense attorneys, depending on the nature of the charge, especially if it's like, somebody says, oh, he hit me in the face. I think my client needs to get up on the stand and say, no, I didn't, if they're pleading not guilty. But do they have to? No. And can the government call them to the stand and make them say, I'm taking my Fifth Amendment privilege and I refuse to testify? No, because that's considered too prejudicial. So you can't even mention that they're taking their Fifth Amendment. The problem, in my perspective, is that when people take the Fifth Amendment and don't testify on their behalf, especially if it's a crime about moral wrong, stealing or punch somebody intentionally in the face, I think the jury wants to hear that defendant get up there and at least make a denial openly. But jurors do not have to testify. Defendants do not have to testify because of that privilege. Now, because our society in the 1960s, in this famous case, Miranda versus Arizona, that defendants are ignorant of their rights. Most defendants, not all, many defendants are poor. They're ignorant. They're disenfranchised. They don't have civic knowledge. And in order to make the rights meaningful in the Fifth and the Sixth Amendment, we came up with this principle. The court did. It's a court-made rule. The court could change it someday. I don't think they will too much, maybe a little bit. That in order for you to be able to voluntarily give up rights, you have to know about them. So that's the Miranda warning. And the Miranda warning, I should have pulled it up so I could read it verbatim. And that's why cops get in trouble too, because they'll say, oh yeah, I read him the rights. And I said, did you read it from the card? And they say, no, I have it memorized. They'll say, please read it now in court from your memory. Sometimes they can't. Kind of a funny moment, kind of cruel too, because they're nervous. But It's the fundamental is that they have a right to remain silent, and that the information, if you speak, can and will be used against you in a court of law. That you also have a right to an attorney, and an attorney will be afforded to one if you can't afford one to help represent you throughout the process. And then after they give those rights, and then you decide to answer questions, well, now the information can be used against you. Now, what if I get if I get arrested and the officer doesn't read me those rights, and I just start spilling out, I haven't been read my rights, and I just started, I killed my wife because she's driving me crazy. She burnt the lasagna, and I hate it when it's burnt. Lasagna is my favorite food, so she had it come in, so I killed her. Can they use that statement against me? They didn't read me my Miranda. But the problem is they didn't question me. Miranda is only applicable when someone would call it custodial interrogation. One is I'm in custody. I'm not free to leave. I'm under police power of dominion and control, and they're questioning me. If those two things aren't present, the statements I use or said can be used against me. And I don't want to get too deep into the rule, but it's kind of common sense. Say the police arrest me and they just haven't had a chance. I mean, were they supposed to instantly read the right? Maybe just got to clean up the crime scene. Maybe I'm injured. They got to get me to the hospital. All these different things are happening. As long as they're not questioning me in that custodial moment, the things I say can be used against me. I often try to get them suppressed, but that's one of the reasons why I'm a big advocate for body cameras with audio and things like that, is because it's a he said, she said, and then we can prove, hey, the officer was questioning my client. They were clearly under arrest. They can't do that. They can do it, but if they do, anything that my client says will be suppressed, will be thrown out. A lot of people think that if you're not read your rights, somehow the case is thrown out. Not true. They also think that any statement you make is going to be thrown out because the rights weren't read to you. No, it has to be because of questioning. And the Miranda warnings weren't given to you. I had one police officer say that he read the card while he was driving down the road before he asked my client, where he got the heroin and why, was it his heroin in the car and all that kind of stuff. And the officer said he did that. And I said, well, how do you know? You said my client was going in and out of consciousness. How do you know my client wasn't? Well, I was looking in the rearview mirror while I was reading from the card, while I was driving down the road, while I read them the rights. And he goes, I also have it memorized. And that was one of the officers that I asked. I said, well, you also have it memorized. Can you go over the Miranda warning right now? And he couldn't do it. He couldn't do it. I don't know if it was out of nervousness, but he couldn't do it. And it was just implausible what he did. And so I got the evidence of my client's statement. Now, that doesn't mean the charges go away. The client was still charged with possession of heroin, and they still had a lot of proof because my client's car, it was registered and there was heroin found in it. But the question made it much more difficult for the government to prove the case because the statement my client said against himself could not be used because they failed to Mirandize him appropriately. A lot of people hate that rule. A lot of cops think it's outrageous. A lot of you probably think it's outrageous. But think about it. If you are going to be able to invoke your rights, you should know what your rights are, so you know the right to remain silent exists. And the other reason is, why do we have it historically? Remember back in the colonial era, we're breaking away from England. What did British military people do and investigative officers do? They would torture you and threaten you and cajole you and basically have an unfair process in order to elicit confessions from you. That's why we don't want that. In fact, there's a lot of evidence, those of you that are criminal justice majors, that coercion in getting confessions often lead to what? People admitting to things they didn't do, or at least incriminating them on side issues because of promises, rewards, or trickery. And that's fundamentally unfair. So we want people to know the rights, that they have a right to attorney, right to remain silent. And it's a very important privilege. And I don't think it's going to go anywhere in our history, or from our future history, great sense, from our future in the criminal justice system, because it really does protect against police. And I'm not saying police are bad, but it's just the nature of all of us. We want to get information, and we want to do it aggressively, and we want to do it thoughtfully. And if it's a slippery slope if we don't have these prophylactic protections for defendants' rights. And the next one's related to, and this one doesn't get talked about, you can't be compelled to be a witness against yourself, which is basically making statements against yourself, but you have the right to do it if you want. The next one's really important. It's not to be deprived of life, liberty, or property without due process of law. The 14th Amendment has that same language, and the 14th Amendment's kind of been taking over. But what can't be deprived? It's vague. What does it mean you can't be deprived of life, liberty, or property without due process of law? The same clause in the 14th Amendment makes it applicable to the states. But we'll talk about it right now. Basically, the courts have told us what this means. and the Federalist Papers and those other documents related to the adoption of the Fifth Amendment, government has to have fair play when they're trying to basically punish someone, take away their money, that's property, or take away their land or their assets, or life, kill them, or liberty, put them in prison. It's got to be a fundamentally fair process. And we get into that later, like notice of the charges against you, to be able to summons people in on your behalf, to give due notice and time to prepare for trial. All these rules related to the Fifth Amendment have developed over time because we want the fair process. And I have no problem. I shouldn't say I have no problem. I like to win every case I'm involved in. But there's sometimes a day where you go into court and you fight the good fight. You have all the information. You've shared it. You know their witnesses. They know mine. We bring them up there. We have a fair trial, and my client gets convicted. Do I feel awful? Yeah, at one level I feel awful. But a few months later, a couple of boxes of wine later, do I recognize that maybe the process was very, very fair and they had their so-called day in court? Yeah, and that's what we're hoping to preserve with the Fifth Amendment's clause on life, liberty, and process without due process of law. Related to it, and this is not a criminal law class, so I do have to talk about it, it's the next one, which is, nor shall private property be taken for public use without just compensation. Very controversial area came up here. So basically, the government is acknowledged to be able to do taking of property by eminent domain or other needs. We need that. And there's actually statutes related to taking over private industry sometimes to benefit the government in terms of times of war or national emergency. But the government has to compensate, and there has to be a hearing. It's also got to be with what? Due process of law. So I know in Fitchburg, it has to be almost 20 years now, 15 years anyways, there was, I think it was, is it Route 12 or Route 13 up there, that they were widening the road, and they had to take people's chunks of their front lawn to make the road wider. It was very controversial. But could the town or the state take away your land? Yes, but they have to provide a hearing to show that it's for the public benefit, and you have to be paid fair market value. And most of the time the government does that. And if you don't think they are, you have a right to a trial on the issue of compensation. What's really gotten controversial is, what does it mean for, and listen to what it says. It says, nor shall private property be taken for public use. When I hear public use, I think roadways, municipal airports, a public hospital, a public school, a public park. Those things are public use. But here's what the Supreme Court did in a very controversial case. And it was down against New London, Connecticut. These homeowners had these like 3-deckers. They weren't the fanciest things in the world, but these people were often multiple generation owners of this oceanfront property down in New London, Connecticut. And this private company wanted to come in. I don't know if it was Merck or Pfizer, one of these pharmaceutical companies wanted to come in and take over that land. And a lot of the homeowners said, we're not selling. I don't care how much money you give. This has been in my family forever. We love it. We're going to keep it. And Pfizer said, we want to come in. Town of, I forget, New London, please take over this land as a government, and then give it to us because we have a better use for it. We're going to raise tax revenue for the community. We're going to help make public schools have more money. All these kinds of things they were arguing. And it went all the way to Supreme Court. Could the town, the city, or the government take away private property from one private group, everyday citizens, and give it to a private company because the end result would arguably be serving a public purpose, raising tax revenue, better schools, cleaning up maybe some blighted areas, whatever their argument is. And the Supreme Court said, yeah, you can do that. That most people find that very unsettling, which finds amazing. And I'm not trying to bang Donald Trump on this, but Donald Trump did exactly the same thing down when he tried to take some people's property when he had his Atlantic casinos. His business tried to basically take by eminent domain, even though it's a private organization, a casino, tried to take some people's home, and he took it to court and saying it was going to basically benefit the community as a whole because the casino would open it and create jobs and tax revenue and all that stuff. And he won. But ironically, when he ran for president, he ran against that famous case on the public taking for private use, saying that it was unconstitutional. But then when he gets questioned, when he had a good point, he says, yeah, but I'm a business person. It doesn't mean I'm going to take it. I'm not going to use the benefit of the law as it currently exists, but I recognize the law doesn't serve our best interests in our country. So he kind of played both ends of that argument here. But I think it surprises people that your land might be able to be taken away by the government. Most people aren't surprised by that. You're going to be paid for it. But most people think it's going to be used for a direct public purpose, not an indirect public benefit by giving it to another private entity. And that's usually what leaves a sour taste in their mouth. I wonder what the court will do today if that kind of interpretation gets revisited again, because it's a case that's almost 30 years old now. But that's pretty much it for the Fifth Amendment, kept under 20 minutes. I'll get to the Sixth Amendment, which has a lot more rights in it very, very soon, hopefully by tomorrow.